The U.S. Supreme Court this morning, just I think it was 7:02 a.m., the first of the decisions they handed down today had to do with a ban of biological boys in girls' sports. And what the court upheld today in a 6-3 decision was that the states have a right to have bans on this to protect girls in sports, to keep boys out of girls' bathrooms and locker rooms, and basically upholding Title IX protections. We have 21 states that currently have these laws in place to protect girls' sports, but Washington is among the remaining 23 states that allow biological boys to participate in girls' sports and use their bathrooms and their locker rooms. Now, Washington voters may well change that come November through an initiative on the ballot. So today's ruling and encouragement for those who want to protect girls' sports. But again, the whole issue is going to be ultimately decided by Washington voters in November. Now, you may recall if you are a follower of this podcast and reader at our Center Square Washington page, you've probably seen stories and on social media they've been prominent. A couple of girls at the center of this fight here in the state of Washington. One of them is 17-year-old Frances Stott. She will be a senior at Tumwater High School this coming September, her final year in high school. And she refused to play couple of years ago in a basketball game. Girls basketball player, longtime player, since she was a little girl, but she refused to play when she saw that there was a biological male on the opposing team. And she said, I'm not going to play against him. He's a man, literally an 18-year-old man. And subsequently, she ended up being investigated by the Tumwater School District and the WIAA, Washington Interscholastic Activities Association. She was ultimately cleared of any wrongdoing, but they accused her of harassment and misgendering because she said, that's a man. I'm not playing against him. I'm a female entitled to do so. So I got reaction today from Frances just after that SCOTUS ruling came down.
So I think that it is a very great decision. I mean, I'm very happy that have been given that opportunity. I think it's really disappointing that it was a 6-3 voting, and the 3 people who voted no are women. So it is interesting to see them not standing up for other girls and women as well. I think that's disappointing. But I also think that although it is a win, it's not done in Washington. We still need people to vote yes in November. We still need people to protect the girls in Washington state because Jamie Peterson, Bob Ferguson, Chris Reichdahl, they will not. And so we need the people of Washington state to stand up and protect us girls because it is a very great accomplishment. It is something that we were praying for and hoping for, but it doesn't change anything in Washington as of now.
The other young lady at the center of this fight here in Washington state who has been so brave and courageous to speak up for protecting girls' sports is 16-year-old Annalie Wilson, a student at Eastmont High School in Wenatchee. Now, she lost a track meet when she was in 8th grade to a boy. She, stood on the podium and had to be knocked down, replaced up on the top by a biological male. Obviously, boys have testosterone and some, ability in sports and competition to be stronger, faster. We know that to be a biological fact. But she became very vocal as a young girl to speak out against this and said, I think this is wrong. I spoke with Annalie Wilson and her mom this morning, Elizabeth Wilson as well, just again after that ruling came down from the U.S. Supreme Court.
We're just hoping that in November, Washington will be able to agree with this and that we can continue moving in the right direction. So, yeah.
Yes, and just going off what the girl said is that, yes, this is our step in the right direction. So we're going to take that win. And there is a lot of work to be done at the ballots. And that's on us as the adults who have the opportunity and the privilege to vote, to go to these ballots and to stand up and protect Title IX and protect our girls.
Now, Initiative 638, which is really IL 26, which stands for Initiative to the Legislature 26 638. Of course, the legislature declined to take these up, even though they're required by our state constitution to do so. So they automatically go to voters on the November ballot. This is an initiative backed by Let's Go Washington, and it seeks to require middle and high school students to compete based on their biological sex assignment at birth. So, barring biological male students from joining girls' sports teams. Now, the group No Hate in Washington State, their campaign manager, Libby Watson, emailed us here at the Center Square a statement following the ruling this morning. And it said in part this: Washington's blanket sports ban is the most extreme proposal of its kind in the country. Unlike the cases decided by the court today, it will require girls who wish to participate in sports to prove their sex through invasive genital examinations. Its impacts will not just be felt by trans girls, but by every girl in our state who wants to participate in K 12 athletics. That has been kind of the argument, and you're going to see it between now and the November election, basically saying, don't support this initiative because boys as well, will have to undergo invasive genital exams. That's what they say. But that really is not accurate. And it is informing people wrongly before they decide such an important issue as this on the ballot. So Let's Go Washington sent me a statement in response to what the No Hate in Washington State group put out today. And that response statement said in part, the initiative does not state the girls will be subject to the exams that Hate in Washington State is so pathetically pushing. In the routine sports exam that already takes place between a doctor and a patient, the doctor and student athlete will decide which avenue to determine their biological gender makes most sense. That can be a verification of their previous medical records, a blood test, history of knowing the patient, or whatever method the patient and doctor determine. Then a doctor checks a box, as doctors already do, on their existing medical form. Again, that's from Let's Go Washington in response to the claims coming from the No Hate in Washington State group, contending that there will be these invasive exams by doctors when that is actually not the case. And we also want to share a statement that we got today from Washington Attorney General Nick Brown, who posted this after the ruling this morning about transgender athletes, writing, it's dismaying that the court would permit states to discriminate against trans student athletes. This ruling does not change Washington law, and we will continue to uphold the rights and dignity of trans youth. Now, I reached out to the Office of Superintendent of Public Instruction, Chris Rakedahl, early this morning, even before that ruling came out at 7 a.m., saying, I'm going to, be waiting for a statement. When my article goes up later today, that should be in time to provide that statement. But just ahead of recording this podcast today, OSPI said they were not ready to provide that statement just yet. But again, it's forthcoming, and I will share that in my article on our Center Square Washington page. So again, despite the ruling this morning from the U.S. Supreme Court, ultimately it's up to the states, and Washington voters will have the final say on this come November.